Hello and welcome to another episode of Perspectives, Fasken's Business Law Podcast. I am Antoine and Iara, partner at the Montreal office, and today I'm joined with my colleague Iara Griffith. Hi, Iara.
Hi, Antoine.
Iara, also from our Montreal office, we're both working on the Charter of French Language, and today we want to discuss the June 1st, 2023 amendments that came into force. Everybody heard about Bill 96 and the modification to the Charter of French Language, but it's not everybody that knew that some provision were coming into force 1 year later, and that's where we are right now. And the first topic we'll discuss are the changes affecting contracts of adhesion, which came into force recently. First, I think we need to do some definition here. So when we talk about the contract of adhesion, Iara, what are we talking about?
Thanks, Antoine. So a contract of adhesion is a contract in which the essential provisions were imposed or drawn up by one of the parties or on that party's behalf or upon their instructions and were not negotiable. So we can think of a website's terms and conditions. We can think of insurance contracts, most insurance contracts, or even an employment contract where the worker or the employee was not able to negotiate essential provisions.
So the adhesion contract, we think a lot about consumer contracts, especially the one online where the terms and services cannot be altered by the adhering party. Once we have established a contract is a contract of adhesion, what was the regime under the Charter before June 1st and what's different since then?
Mm-hmm. So before Bill 96, the Charter required that contracts of adhesion be drawn up in French unless the parties had consented or agreed to a contract in another language than French. So in practice, what businesses would do is just include a language clause whereby the parties agreed to contract in another language than French, but it defeated the purpose of the law because the clause wasn't negotiable, and the parties were never really able to have the opportunity to contract in another language than English. So what changes now under Bill 96 is that there's a French first requirement. So even if you know that the adhering party will want to contract in English or in another language than French, the requirement now is to provide a French version first before the parties can agree to be bound by a version in another language.
And how important it is for that French version, even if we know that the contract will be executed in English, how is it important that the French version is really equivalent to the English version?
Oh, it's paramount, Antoine, because under the modified charter, if there is a discrepancy between the English and French version, the adhering party or the party who did not draft the contract or document can choose either version according to their interests.
What if this requirement not to provide the French version is provided in case of an adhesion contract? So it's not provided, the contract is, for example, in English, it's executed. What might be the consequences of that lack of respect of this particular obligation?
So failure to comply with this requirement can cause the nullity of the contract. So before Bill 96, it was not possible to ask that the contract be canceled or annulled. But with Bill 96, what changes that an adhering party can ask that the contract be canceled without proving injury.
If the adhering party does not want to cancel the contract in its entirety, is there any alternative for that person to take benefit of that failure to provide the French version?
Yes, so a party can also ask that their obligations be reduced instead of asking that the contract be canceled. So they have a series of new remedies. They can even also invoke that a clause is unenforceable upon them because it was only provided in English. And Antoine, I just wanted to circle back on the requirements because it will not apply to any contract of adhesions. There are some limited exceptions. For example, a borrowing agreement, a contract whose object is the management of financial risks. I'm not going to list them all, but there's also an exception for certain insurance contracts which do not have a French equivalent in Quebec, come from outside Quebec, or are not widely used in Quebec.
And last year we discussed the employment contract, who has very similar provision, but different ones. So they're not covered by the same section of the charter. Contract of adhesion, we said earlier that consumer contracts were really often qualify as contract of adhesion. I want now to discuss to the change of the Consumer Protection Act. We had a lot of discussion about the modification to the Charter of French Language or the Charter of Rights or the Constitutional Act, but there are other legislation, the Civil Code of Quebec, but the Consumer Protection Act also is modified by Bill 96, and there are specific provisions that came into force on June 1st, 2023. What are they?
The Consumer Protection Act now requires that consumer contracts, which have to be in writing by law, be provided in French first to the consumer. So it's a very similar rule to that of the Charter of French Language for contracts of adhesion, but you have the equivalent for consumer contracts that have to be in writing.
Does this new obligation brings additional remedy to the consumer on top of what we discussed on the Charter of French Language?
Absolutely, Antoine. Because as some of you may know, the Consumer Protection Act is very favorable towards consumers. There is a very important regime for damages, including punitive damages.
Speaking of other legislation that were modified by Bill 96, we have the Act respecting the legal publicity of enterprises that was modified as well. Can you explain what's the French component to that legislation that came into force and that will require many enterprises to change the way they do their declaration every year?
Yes, Antoine. So Bill 96 modified the Act respecting the legal publicity of enterprises to require that enterprises that are subject to this act and employ 5 to 49 employees in Quebec declare the proportion of their employees who are not capable of communicating in French. So just to clarify, this requirement applies to enterprises with at least 5 employees, but that are not subject to Francization requirements. So starting at 50 employees or more, other requirements apply under the Charter. An enterprise must register with the OQLF and start its Francization process. But until then, so for enterprises with 5 to 49, these businesses must declare the proportion of their employees who are not capable of communicating in French, and that is done as part of their annual declaration or mise à jour courante with the Registraire des Entreprises.
So that threshold in 2 years will be reduced to 24 employees because every enterprises with 25 employees and more will now be subject to Francization requirements. So just so everybody understands, in practice, what it changed is an additional question in the declaration. So let's say we have 10 employees, 2 of them are not able to communicate in French, then the answer will be 20%, right?
Exactly. And this information will be public. The purpose of this change is intended to help the government determine what enterprises are going to be offered free French courses.
So that's going to help Francization Quebec to allocate their resources in order to train employees in their French language capacity. The last topic, but a very important one, is related to the changes affecting the civil administration. And therefore all the parties that contract with it. First, a question of definition. When we are referring to civil administration, what are we talking about?
The Charter offers a broad definition of civil administration in its Schedule 1, but in short, the civil administration includes the government, government departments, government bodies, municipal bodies, school bodies, bodies in the health and social services network, and the rest are in Schedule 1.
What is the paramount principle that comes into force on June 1st, 2023 that affects the civil administration?
Well, that would be exemplarity. So an exemplary use of French, which is basically an exclusive use of French wherever possible.
So that's in writing, that's oral use of the language, so that's in all the day-to-day activities of the administration. I understand it might change the language of work or, internally how the employees of the civil administration behave. But for our clients that contract with the civil administration, what are the obvious changes that are coming to them?
Mm-hmm. So it's important for businesses who contract with the government to know about these requirements because when they offer services or enter into an agreement with the government, their use of another language than French will be greatly limited, restricted to the exceptions that are set forth in the Charter and its regulations.
Contracting is one thing, so in principle it would have to be in French, but the execution of the work, what will be expected from businesses that do enter into a contract with the civil administration?
So as a service provider, that an enterprise or business will be expected and required to offer services in French, just like the government would have been required to if it was offering the services itself.
There is the Politique linguistique de l'État. There are 2 bylaws that came into force on June 1st. Can you tell me more about it?
So the Politique linguistique de l'État replaces its previous version that was last updated, I think, in 2011. And it sets forth the great principles or general principles according to which the state must use French in an exemplary manner. The policy also states that the Charter was not amended to infringe upon linguistic community rights. So the goal is not to infringe upon Indigenous traditions or Anglophone communities. And the 2 regulations specify exceptions that are set forth in the Charter, and the exceptions where a public body can use another language than French, more often in addition to French than in lieu of French.
So the principle is the exclusive use of French, and most of the exemptions permit to use French and another language instead of exclusively French. And there is a very limited number that permits to do anything with the state in another language than French.
Exactly.
Coming back to the obligation to be in good standing, okay, with the Francization obligation and not to have any pursuit against the company for the use of the language. What's the consequence when you talk about entering into a contract with the state if you're not in good standing?
Mm-hmm. So, Antoine, before Bill 96, the Politique linguistique de l'État already stated that the government shouldn't enter into agreements with businesses that are subject to Francization requirements and that are in bad standing with regard to these obligations. Now this requirement was incorporated in the Charter, so it's it's a strict obligation now for the government not to contract or grant a subsidy to a company that is in bad standing with the OQLF. So It could be that the company is required to register and has failed to do so. It could be that the company has not put in place a francization program where the OQLF had ordered it to do so. It could be that the company is on the OQLF's blacklist. And there are limited exceptions in the regulation for the government to circumvent this prohibition, but the rule is that the government cannot enter into a contract with a company that fails to comply with francization requirements.
So for any business doing regularly business with the government, it's very important to make sure that they are in good standing and that they take specific action to be compliant with the Charter of French Language. Speaking of failure to act in accordance with the Charter, can you remind us what are the powers that the OQLF have to enforce the execution of these obligations?
Bill 96 gave teeth to the OQLF because before this reform, the OQLF had a power to give formal notices and, letters, a slap on the hand to companies that did not comply. But now it has the power to issue orders, and a failure to comply with an order is a prosecutable offense that can be prosecuted by the government and can result in penal fines. The OQLF also has the power to seek an injunction from the Superior Court to ask that a company or individual be forced to comply.
Well, that was the point that we want to make in order to remind all of you of the changes at the Charter of French Language that came into force on June 1st. Thank you, Iara. For more information about the changes implemented by Bill 96, please go to our resource center, on which you will find an annotated legislation. You would also find a self-assessment tool, and we do also the review of all the judicial proceedings. So you have copy of the proceedings, copy of the judgment, and we'll be updating that page as we go. You can also contact a member of our team for more information. So thank you for listening to our podcast, and we invite you to listen to the other episodes of Perspectives or even subscribe to our podcast series on your favorite podcast app.